Okay, to break down what we learned today from the Prime Minister's testimony, we brought in some experts because I have a degree in literature and history. Stephanie Carvin is an associate professor at Carleton University's Norman Paterson School of International Affairs. Professor Carvin specializes in national security issues. Leah West is an assistant professor at the Norman Paterson School of International Affairs, and Professor West specializes in national security law. Thanks for doing this again on another Friday. We appreciate it. Stephanie Carvin, I want to start with you. Your big picture takeaway from what we heard from the Prime Minister today as he laid out all of his reasons for what he did.
So I guess my first impression was, and maybe this is unfair, but I thought he did a really good job in terms of laying out the government's arguments, or at least in terms of what he was thinking, what he was hearing, and what he knew when he knew. And also he demonstrated like a lot of familiarity with the legislation, the act itself. At one point he had an engagement with the lawyer from Saskatchewan and went through in detail the differences between a public welfare emergency, a public order emergency, and what how you consult on those bases. So I think, he had the responsibility to answer a couple of key questions, which was why did he feel that he had to invoke the act? But also, why didn't he want to meet with protesters? Like, what did he think that would accomplish? And why didn't he believe that there was a police plan in place that necessitated this move? Yeah,
Leah West, there was a lot of ground covered, over the 5 weeks. And even then it felt rushed because of just the time frames there. But on this central question that we've been talking about, of whether the act was appropriate, the use of the act was appropriate, because that's really at the center of all of this. Where do you think the Prime Minister left us with what he had to say today?
I thought he presented a very compelling argument that he and Cabinet had reasonable grounds to believe that there was a public order emergency and that measures were necessary. However, as we've heard throughout, that was based on a particular piece of legal advice, and that piece of legal advice remains classified. We don't know what it is. He wouldn't go into detail. He talked about something that he did more compellingly than his other ministers, talked about the serious threats of violence that he felt gave rise to a threat to the security of Canada that would justify the invocation of the public order emergency. But his answers and the legal advice remain contentious because we have not seen that advice, and it does seem to conflict with our common understanding of how we read the CSIS Act, or we read CSIS Act into the Emergencies Act. So that question remains unresolved.
Okay, I want to deal with that question, and for the control room, what we've cleverly titled clip number 7, if we can get that queued up, because this is where the Prime Minister walks through his sort of reasoning of why they felt they're not bound by the definition strictly in the CSIS Act. But as you point out, the legal advice on that is still covered by solicitor-client privilege, so we don't know what happened. But here's the Prime Minister in his own words, so just have a listen to this.
Those words in the CSIS Act are used for the purpose of CSIS determining that they have authority to act against an individual, a group, or a specific plot with, for example, a wiretap. That in order for them to take action in a particular situation, that threshold needs to be met of threats to national security. This definition within a declaration of public order emergency under the Emergencies Act is about the Governor and Council finding reasonable grounds that there are threats to the security of Canada sufficient to invoke the Emergency Measures Act. So both the context and the purpose is very different.
So there's his explanation. So Stephanie Carvin, if you agree with the argument that the CSIS Act is what applies, they didn't meet the test. But if you agree with this broader definition that Cabinet is basing this decision on, there's an argument that they did make the test. I mean, what do you make of the way the Prime Minister explained it there in terms of convincing Judge Rouleau, who's ultimately going to weigh in on this?
Well, I just want to say first, I agree with Leah that we haven't seen the specific legal advice, and that's unfortunate.
It's a huge problem.
Yeah, no, I mean, like, look, and the whole point, I think I've said this before, like, this is the national security Super Bowl. I think, I agree that there's solicitor-client privilege, as the government lawyer said multiple times today, but it's time, you need to show this to Canadians, and it's kind of odd to me that you would have your, and this is the point Leah made that I'm stealing, but odd that you would have members of Parliament vote on something where they haven't necessarily seen the legal advice for. But I mean, look, we also live in a system where, our Constitution grants the executive the power to interpret statute. And in this particular, and it can't just do anything it wants with the statute, right? There's tests, there's, was it reasonable, necessary, things like this. There's a whole body of administrative law that goes along with that. But there is a degree of flexibility, and what this is going to come down to, I think, is Justice Rouleau saying whether or not it was too flexible or whether it was there. But I don't think the argument they're putting forward is unintelligible, but it is certainly novel. And this is where I would have liked to have seen that advice. Right.
So, let you people in on a little. We text about this all day when things are happening. And Leah West, you made the point in the group text today that Trudeau is making a compelling argument if you're not a lawyer, right? So now Judge Rouleau is a lawyer. So how do you think he responds to that argument?
Well, one of the things to me that was very important hearing from the Prime Minister was the fact that all week we've heard from ministers and even last week saying we need to take into account various inputs. We're considering things CSIS is not considering. Right. And so it's not that we're interpreting it more broadly, but we're considering different things. But when asked what he considered and what got him to the line that there was a 2C threat, so the serious risk of violence that was politically motivated, he outlined various factors that would have been top of mind for CSIS. He wasn't talking about things that CSIS wouldn't have considered, like the weaponization of vehicles, the fact that there were people with extremist motivations present, the fact that there were weapons. These were all things that CSIS would have considered, and yet CSIS didn't get there. What we heard from other ministers and other members of cabinet and the clerk was that we considered the economic harm, we considered the trading relationship, we considered all that other stuff, which normally, we wouldn't consider a threat of serious violence, right? So he did go really much more narrow to a more finite, security risk, and he even, when asked by counsel, well, what about the economic harm? You seem to rely a lot on the economic harm in the Section 58 justification. He said, no, what I was really concerned was about threats to Canadians' lives. But I don't see how you then come to a different conclusion than CSIS if that's your main concern.
Okay, so going back to the group text, Steph Carvin, you made a point, and I have described what was happening as this constellation of events, right? It was a series of pinpoints across Canada. Not any single one of them was a gigantic crisis, but taken together, this is what the government would consider to be a national emergency. And you've made the point that a constellation is not what CSIS looks at, it's a supernova that they're looking for. So how does this kaleidoscope of issues factor into maybe the way the national security agencies would assess whether this truly was an emergency?
Yeah, I mean, and this is far more elegant than I think I had like a duck-sized horse. Sorry, duck-sized horses and a duck the size of a horse, which is a bad internet analogy. But yeah, this constellation, I think this is part of it. Like, if you look at what the government was saying and what actually Justin Trudeau and other cabinet ministers mentioned at the time, they believe that the protests are actually escalating, right? Post-Coots, that there's continuous attempts to retake the border, which there were. They talk about the protests becoming more intense, possibly growing in size, if not necessarily intensity. And that's the kind of thing that they're dealing with. And yeah, I mean, this is the problem. Like, I've looked at it on an individual basis. Yes, CSIS is not going to declare any one of those things, I think, a threat to the security of Canada. But then the government has to be concerned with this kind of broader constellation of issues. And I think this is something that, again, Justice Rouleau is going to have to consider. And it is interesting to me, like in other cases like foreign policy and defense policy, the executive is given considerable leeway. Mm-hmm. But in national security, we have far more narrow laws. And this law was designed to be kind of tied to this CSIS Act, which, again, in the courts tends to be interpreted pretty narrowly. So it's going to be interesting to see where he falls on that. Does he go with that, like, kind of constellation of threat argument, or does there have to be that supernova in order to actually go ahead?